Hello, good morning. Are you able to hear me and am I audible and visible? Good morning, Nasifa, Saksham, Alamelu, Soumya. Am I audible and visible? Okay, good morning, Lipsag. Okay, thank you, Alamelu. Good morning, Gayatri. So, there was a severe network issue at my end, and finally it is fixed now. And the network here seems to be very unreliable. So, I am going to wrap this up very quickly. Okay. So, today's topic is the impacts of social media on law. I mean, the social media, the invasion of social media has impacted the law, and the law is also impacting the social media now, because as and when there is a boom in the digital revolution. We can see there is a very you can say very robust boost in the social media in the digital revolution, and it has affected law also, because it has prompted the state, it has prompted the parliament to legislate various laws on these issues. Okay, it has prompted the parliament and the state to legislate various laws to regulate the social media. Okay, until now we can see we saw that social media platforms like Facebook, Twitter, they were unregulated, completely unregulated up until 2000, when Information Technology Act 2000 was finally legislated. And Information Technology Act 2000, under section 89 of the Information Technology Act 2000, the Parliament was empowered to make rules. And in 2011, the Parliament made rules, the Information Technology Rules of 2011, which hardly covered these social media platforms. And then we saw that there was an innovation of web series of various web portals like Hotstar, Disney Hotstar, Sony Live, Zeev Premium, and this Netflix, Amazon Prime. I mean, these kinds of web portals are a recent invasion. Okay, and because of this, the Parliament had to legislate even more laws, and it replaced the 2011 acts, and it introduced the Digital Media Ethics Code Rules, Intermediary Guidelines, Information Technology Intermediary Guidelines, and Digital Media Ethics Code Rules of 2021. Okay, so this was introduced recently in 2021 by the Parliament, by the government. So the question is that the social media is impacting the law, and the law is changing its course as and when the social media is turning or transforming its various phases. Okay, so the impacts of social media on law, our ability to communicate through language and gestures gave us humans a distinct evolutionary advantage than other species. We humans are social beings, and we need social interaction. Words bonded us. Our linguistic ability was one of our momentous accomplishments. However, how we communicate between ourselves has gone through changes with the ever-changing times. It has been a long-lasting peregrination that started from the earliest cavemen to the earliest civilization until this very era of globalization and modernization. It is striding on. The only difference is those cavemen used to paint symbols on their cave walls. We use emojis. Technology has simplified our lives, and it has also changed the way we communicate these days. Hashtags, memes, acronyms, posts, likes, comments, shares, tweets, mentions are just we stay in touch with each other and with the entire world. These days, look at the transformation in the communication. Earlier, people used to use walls for painting symbols. They used to express their ideologies, their thoughts, their perceptions, their beliefs while posting something on the wall. But this wall has changed. We also paste on our wall, but our wall happens to be digital. Okay, you used to use symbols. We are using emojis. Okay. Then these days, when someone mentions social media, we visualize sites like Facebook, Twitter, Instagram, Snapchat, WhatsApp, etc. Some of you may not even remember a world without social media, which is hysterical and amusing. To be candid, it's also difficult to imagine a world without social media. In this day and age, these social media sites are not just sites where you upload your favorite selfies and memes, but it has become a powerful weapon. A weapon, if used rightly, can bring people together, give voice to the masses who remain unheard, bring down corrupt dictatorship like the one we witnessed during 2011 in Egypt, where hundreds of thousands of protesters gathered in Tahrir Square, which later unseated the president, Hosni Mubarak. These protesters used Facebook to schedule the protest, Twitter to coordinate, and YouTube to tell the world. But there's always two sides to a coin. Sometimes people also use social media for cyberbullying, spreading fake news, trolling, catfishing, and privacy abuse. But the most sinister and blood-curdling usage of social media is done by terror groups. Al-Qaeda is one of such groups which uses social media extensively. Islamic State in Iraq and Syria, or ISIS, is another such group that uses social media as a medium to threaten the masses by posting videos of beheadings. This paragraph tells us that how important and how significant social media it is in the present times, and what important role actually it is playing. Exactly, Nasifa. It has its own advantages and also disadvantages. The question is about that social media is being used to organize protests, hold revolutions. What happened during the CA NRC protest in 2019? Delhi, Bangalore, Hyderabad, Lucknow, Aligarh. These are everywhere, almost everywhere in every important city. There were huge protests against CA and NRC. And these protests were organized, planned, and scheduled on social media. People used social media, and the state used to cut down the internet services. It used to shut down the internet services in almost every area. I live in Aligarh. I used to live in Aligarh some time back, and I saw that the state was using this shutdown policy for disconnecting every person from the other person. Okay. Because people used to post that you have to gather here on this spot by this time, and then people, when used to see such kinds of posts, they used to reach there. Okay, you must have remembered the Bengaluru violence. Bengaluru में riots हुए थे. It was because of a fake Facebook post. So these kinds of things are very important. Egypt में, यहाँ पे जो paragraph में explain किया गया, in Egypt में people gathered in Tahrir Square, and the President Hosni Mubarak was unseated in 2011. These protesters used Facebook to schedule the protest, Twitter to coordinate, and YouTube to tell the world. But there's always two sides to a coin. Sometimes people also use social media for cyberbullying, spreading fake news, trolling, catfishing, and privacy abuse. But the most sinister and blood-curdling usage of social media is done by terror groups. Al-Qaeda is one of such groups which uses social media extensively. More than 1.5 million pieces of content, web links, news stories, blog posts, notes, photos, etc. are shared on Facebook daily. Social media has overtaken porn as the #1 activity on the web. 1 out of 8 couples married in the US last year met via social media. It took the radio 38 years to reach 50 million users. The television took 13 years and the internet took 4 years to gain 50 million users. But Facebook added 100 million users in less than 9 months. If Facebook were a country, it would be the 4th largest country, ranking itself after China, India and the US. Companies are using LinkedIn as their primary tool to find employees. It is clear that social media isn't a fad. It's a fundamental shift in the way we communicate. Changing times. It would be easy to ignore how social media impacts society as a whole. The power of social media has instigated various social changes. Its fierce presence has been organized in the legal environment as well. Law and social change go hand in hand. Law is both independent and interdependent on the social system. The changes in a particular society can be studied by studying the law, and by studying the law one can understand the changes in that particular society. Ergo, law is the reflection of the will and wish of the society. India has one of the highest numbers of internet users and the highest social media presence in the current scenario, and this will only keep on increasing. These days, almost everyone owns a smartphone which comes with a package of pre-installed social media and other apps. With just a few clicks and your online profile is created, one does not need to submit any kind of ID proof or any kind of document. Sounds very convenient, right? It's due to this convenience that it has been often misused. With great and new increase in technology emerges a great and new kind of crime called cybercrime. Cyber stalking and online harassment is a very quotidian occurrence in the world of social media. The wheel of anonymity gives these perpetrators a false sense of security. In this techno-savvy day and age where an individual is heavily dependent on this highly digitalized world of e-commerce, e-business, e-governance, e-procurement and emails, laws related to cybercrime was the need of the hour. IT Act 2000 was one of the first steps India took to address various offences related to cybercrime. IT Act 2000 incorporated not just any and all inconceivable cybercrimes against a person, but also included cybercrime against government and property. It also encompassed laws relating to not only cybercrimes but intellectual property, data protection and privacy. Offences such as cyber stalking, impersonating identity theft, violation of privacy, publishing obscene or sexually explicit material including that of a child, a person who has not completed the age of 18 years, are recognized as cybercrime against a person and are punishable under Information Technology Act 2000. So are you getting my point? Yes, it's acting as a drug nowadays. You know, people are in the social media industry, they are known as consumers. Okay, I mean they are known as users. Sorry, users. There is one just drug industry which uses the term user for the customers, and the other industry is social media industry, which uses the term user, not the consumer. Okay, we are using it and we are getting addicted to it like drugs. So are you getting my point? The paragraphs and the article are simply written and you must have a good idea about these cyber crimes and these kinds of cyber phishing and theft, identity theft, anonymity and all that, isn't it? Now, serious offences like cyber terrorism, which is considered as cyber crime against the government, is punishable with imprisonment for life. This act also acknowledged computer vandalism, siphoning of funds like cyber frauds, isn't it, online frauds from financial institutions, siphoning of funds from financial institutions, stealing data and copywriters offences. These offences are cybercrime against the property. Cybercrime such as credit card fraud, hacking, virus attacks, online banking fraud, pornography are becoming run-of-the-mill events. According to National Crime Records Bureau or NCR on Monday, during 2017, 56% of cybercrime cases registered were for the motive of fraud, followed by sexual exploitation with 6.7% and causing disrepute with 4.6%. The case of cybercrime in India have clearly doubled. In 2014, 2015 and 16, India recorded 9,600 9622 11592. Ones, tens, 100,000, 10,000, lakh, 10 lakh, crore, 10 crores. It's 96 crores, 22 lakhs, 11,592 and 12,317 cases of cybercrime respectively. Now you can imagine the level of danger involved in this is a virtual world. This is not reality. Okay. Now, admissibility of social media as evidence. Absence of evidence is not evidence of absence. Carl Sagan. According to Locard's principle of forensics, which states that the perpetrator of a crime will bring something into the crime scene and leave with something from it. This principle is also applicable to cybercrime. Like fingerprints in a crime scene, social media can provide an irrefutable trail that investigation agencies can use crime. But we need to understand that, like any other evidence, these sites can provide not only tangible evidence of criminal or civil disobedience. In criminal cases, law enforcement looks for the presence of the crime itself or corroborating evidence of a crime. On the contrary, a civil investigation pertains more to finding evidence that supports a claim. Regardless, social media evidence is considered a form of digital evidence, which for all the intents and purposes is a relatively new aspect in the field of investigations. A crime primarily has four key: state or mens rea, conduct or actus reus, we all know this, concurrence and causation. What are the four key components of a crime? Mens rea, actus reus, concurrence and causation. And to prove that one has committed a crime, the prosecution needs evidence. The burden of proof mostly lies on the prosecution, except in a few exceptional cases. In the eyes of law, a person is innocent until proven guilty. The guilt must be proven beyond a reasonable doubt. Evidence becomes an instrument to satisfy the court to prove or disprove a disputed fact between the parties involved in litigation. There are various forms of evidence other than the traditional forms of evidence like physical, testimonial, circumstantial, etc. Electronic evidence has been accepted recently and is considered as documentary evidence. Section 3 of the Indian Evidence Act recognizes electronic evidence as evidence. There's a recent amendment also. Okay. There's a recent amendment also in the Indian Evidence Act to include electronic evidence as an evidence. Okay. Exactly, Nasiba. We are falling as prey to these online platforms due to lack of knowledge and literacy. Exactly. Okay. Now, in its rawest form, social media can be considered a form of evidence, but unlike traditional criminal evidence, social media takes on the unique form of electronic or digital evidence. By definition, electronic or digital evidence is any probative information stored or transmitted in digital form that a party to a court case may use at trial. Such form evidence, especially that of social media, tends to be more capacious, more difficult to destroy, easily modified, easily duplicated, potentially more expressive, and more readily available than traditional forms of evidence. But before accepting digital evidence, it is mandatory to determine its relevance, veracity, and authenticity by the court and to establish that whether the fact is hearsay or a copy is preferred to the original. Okay. In 2017, Haryana court recognized WhatsApp chats as evidence to convict 3 law students of rape. The 3 former students of OP Jindal Global University were held guilty for blackmailing and raping a student of the same university for 2 years. ASJ Sunita Grover said that the messages proved that the victim was forced to keep sharing nude pictures with the culprits. The court considered the chats as documentary evidence supporting the victim's statement. Okay. However, in another incident, Justice Sanjeev Sachdev observed while hearing the petition for registering the FIR connection with an alleged suicide note claimed to be of Arunachal Chief Minister Kalikhopul, a WhatsApp post does not qualify as legal evidence, especially when neither the original nor a copy of the original document is produced. Such a form of evidence needs corroboration. However, Justice Sanjeev Sachdeva said this, but at the same time we see that the chats, online chats, they were held to be as good evidence for convicting the 3 law students. Okay, so electronic evidence is now considered as a good evidence. Okay, then our judicial system is to a great extent based on the British legal system. The modifications that the Indian judicial system has experienced, the United Kingdom underwent similar transformations. Social media and other electronic forms of communication is such a formidable force that cannot be ignored by any judicial system or any nation. Emails are admitted as documentary evidence in the UK. The Code of Practice framework to determine the reliability of such electronic forms of evidence. Okay. Are you getting my point? Are you getting any question? If you have any question, you can ask. Any question up till here? Only then we can move ahead. Okay. In a 2018 case of Force versus Sikarma, WhatsApp messages furnished the evidence which guaranteed the success of Sikarma at the very interim injunction stage of the trial. The powerful impact of social media is well recognized in the US legal environment. Alteration of privacy settings, deactivating social media accounts, deleting any content, all these falls under the unlawful destruction of evidence. The federal law known as the Stored Communications Act states that a person or entity providing an electronic communication service to the public shall not knowingly divulge to any person or entity the contents of a communication while in electronic storage by that service. Law enforcement and government entities that have good faith are prime exceptions. Privacy rights are overruled when social media contradicts injury claims. US में the whole cyber law jurisprudence has fully developed in US. There's one federal law known as the Stored Communications Act. Okay. And it states that a person who or entity providing an electronic communication service to the public shall not knowingly divulge to any person or entity the contents of a communication while in electronic storage by that service. Okay. In Romano versus Steele case 2010, a famous personal injury case, the Supreme Court of New York recognized electronic discovery or e-discovery, issued discovery orders granting the defendants access to the plaintiff's Facebook and MySpace account, including all the deleted pages and information. Justice Jeffrey Spinner rejected the plaintiff's argument that the production of such information would violate her right to privacy. In Zimmerman versus Wees Markets, another personal injury case from 2011, where the judge ruled in the favor of the defendant and permitted discovery and access to the plaintiff's Facebook and MySpace accounts to refute the claim of the plaintiff that he suffered permanent injury to his health and wellness. Okay. Now there are questions from Lipsa. Does commenting on government still considered as sedition? See, sedition and freedom of expression, they have a very thin line of difference between them. Very thin line of difference. Sedition is when you are prompting the people to resort to violence and you are creating a sort of insurgency against the government. But freedom of expression includes a reasonable criticism of government and its policies, laws, and its style of governance. Okay, so sedition, however, has been misused by the governments time and again. And recently, you know this, that the Supreme Court just the day before yesterday in a very historic judgment has withheld all the proceedings of sedition going on in any part of the country. Okay, Nasifa Khatun is asking, is any specific legislation curtailing such misuse of the social media? We have Information Technology Act 2000. We have intermediary guidelines, information technology, intermediary guidelines, and digital media ethics code rules 2021. Okay. What do you mean by right to forget, Lipsa? Now, the social media revolution, I'm resuming from this paragraph. The social media revolution has truly changed the face of the investigation. And Facebook and Twitter have become one of the most underrated sources for law enforcement. According to a 2012 study conducted by the LexisNexis, 4 out of 5 officers used social media for investigative purposes from a total of 1,221 law enforcement professionals surveyed. Of the agencies surveyed, 82% of local and municipal law enforcement agencies utilized social media for investigative purposes, with only 71% of state agencies utilizing social media for the same purposes. Additionally, 86% of cities under 50,000 people utilize social media in some respect, while only 78% of cities over 1 lakh people use social media in the same capacity. A growing number of people joining social media every day makes it an efficient tool for law enforcement to monitor activities of any suspect. The undeniable and strong presence of technology has been acknowledged by various courts in various forms. The courts are not hesitating to use social or digital media in innovative ways. Okay. Now, in the same year of 2017, the Rohini Civil Court in Delhi accepted WhatsApp blue double ticks as receipt proof. Senior Civil Judge Siddharth Mathur accepted the printout as proof that notice had been read by the recipients and concluded that defendants had acquired the knowledge of the scheduled hearing. That means now the summons can be issued on WhatsApp, the notice for appearance in the court can be issued on WhatsApp, and once they are blue ticked, that means it is an acknowledgement of the receipt of the notice. So, and it was considered as a receipt by Senior Civil Judge Siddharth Mathur. Okay. In another incident, Justice Rajiv Sahai in-law, while hearing a case filed by Tata Sons, allowed the plaintiff to serve the summons on one of the defendants through WhatsApp, email, and text messages. The 3 defendants were served at their respective addresses, but as the summon could not be completed at his address, the Delhi High Court allowed this move. The infamous 2G case was one of the first instances where the court considered summons via email as a valid summons. However, very recently in 2018, Special Judge of Patiala House Courts, New Delhi, dismissed the application of a complainant who sought the usage of email and WhatsApp for serving a summons. Okay, now determining authenticity. In India, now Nasifa Khatun is asking, sir, in these cases, the curtailment of fundamental right of free of his speech and expression is justified. See, it is sometimes justified and sometimes it is not. So here we are not specifically talking about the curtailment of fundamental rights. We are more concerned about in this lecture regarding that how this social media is impacting the law and how the law has to change its course whenever there is some transformation in the social media. Okay. Now, determining authenticity. In India, law enforcement identifies a suspect and then asks platforms to supply information about them. For example, WhatsApp requires a mutual legal assistance treaty, request or letter rogatory to compel the disclosure of the contents of an account. WhatsApp will take steps to preserve account records in connection with official criminal investigations for 90 days pending the receipt of the formal legal process. One can also expeditiously submit formal preservation requests via the WhatsApp law enforcement online request system. In responding to a matter involving imminent harm to a child or risk of death or serious physical injury to any person and requiring disclosure of information without delay, a law enforcement official may submit a request via the WhatsApp law enforcement online request system. WhatsApp strictly refuses to review or respond to requests submitted by non-law enforcement officials. WhatsApp also does not retain data for law enforcement purposes unless they receive a valid preservation request before a user has deleted that content from their service. Because WhatsApp does not store messages once they are delivered to transaction or transaction logs of such delivered messages, according to them, undelivered messages are deleted from their servers after 30 days. Okay. Lipsa is asking what happened in Rohini code blast. How did that happen? Rohini, I have not followed that case, so I don't have idea. So I really beg your pardon on this. I would rather like to plead ignorance on this issue because I have not followed the facts of that case. The evidentiary value of an electronic record totally depends upon its quality. Provisions regarding dealing with the evidentiary value of the electronic records are discussed in the Indian Evidence Act 1872. Discussions on the authenticity and admissibility of documentary evidence in the form of an electronic record and its standards at par with the conventional form of documents are dealt with in the Indian Evidence Act. The evidentiary value of electronic records is widely discussed under Section 65A and 65B of the Evidence Act 1872. Section 65B of the Indian Evidence Act lays down the conditions and procedure of proof of an electronic record in a court of law. Section 65B is important as it recognizes that the original primary evidence of electronic records cannot be expected to be brought before the court, and even if it is, the same being in binary form, the same cannot be understood by the court. The net effect of Section 65B is that the output in the form of a printout or data copied on CD, DVD, etc. produced by the computer is rendered admissible in the court, provided certain conditions are met. This is the import of Section 65B1. The output of an electronic record, in order to be admissible in a court of law, has to be filed along with the certificate under Section 65B4 of the Evidence Act. There has to be a certificate about the authenticity from the concerned authority that this electronic evidence is authentic. You know this, you've already read this. Such a certificate has to be issued by a person occupying a responsible position with respect to the computer from which the data is produced. The certificate has to certify the conditions laid down in Section 65B2 relating to the integrity of data and computer system, the manner of production of the output of electronic record, identity and particulars of device is used including the original device. Okay. Now, this entire data behind the certificate is to ensure once again that the integrity of source, the authenticity of the data, so that the court can place reliance on it. Like this certificate acknowledges the court that the court can, easily rely on such evidence. Okay. This is important since electronic data is more prone to tampering and alteration. In Kundan Singh versus the State 2015, the court stated that a certificate under Section 65B can be filed even thereafter and need not be filed alongside. The sections provide that if the four conditions listed are satisfied, any information contained in an electronic record which is printed on paper, stored, recorded or copied in an optical or magnetic media produced by a computer is deemed to be a document and becomes admissible in proceedings without further proof or production of the original as evidence of any contacts of the original or any facts stated therein which direct evidence would be admissible. Now the four conditions. What are the four conditions referred to above are: the computer output containing such information should have been produced by the computer during the period when the computer was used regularly to store or process information for the purpose of any activities regularly carried on during that period by the person having lawful control over the use of the computer. Okay. During such a period, information of the kind contained in the electronic record was regularly fed into the computer in the ordinary course of such activities. Throughout the material part of such a period, the computer must have been operating properly. In case the computer was not operating properly during such a period, it must be shown that this did not affect the electronic record or the accuracy of the contents. The information contained in the electronic record should be as such reproduced or is derived from such information fed into the computer in the ordinary course of such activities. Okay. Now, let us look at, we have section 63 and 65 of the Evidence Act. Now we have Information Technology Act 2000, and new definitions have been given to the word data, electronic record and computer. New section 22A has been inserted into the Indian Evidence Act to provide for the relevancy of oral evidence. Okay, to provide for the relevancy of oral evidence regarding the contents of electronic records. Just a second. Regarding the contents of the electronic records, it provides that oral admissions regarding the contents of electronic records are not relevant unless the genuineness of the electronic records produced is in question. Section 59 of the Evidence Act is amended by the IT Act to exclude electronic records and inserted section 65 provisions of section 65B. 65A is for electronic records, such as 61 is for documentary evidence. 65A is a special law that stands apart from the documentary evidence procedure in 63 and 65. Any probative information stored or transmitted in digital form is digital evidence or electronic evidence. Under Indian law, section 69 and 69B of the IT Act 2000 lays down the provisions for investigation of certain crimes that require search upon order by the competent authority. The powers of search and seizure are also laid down under several other rules, such as Rule 3.9 of the IT Act, which includes due diligence observed by intermediaries guidelines, Rules 2011. This allows access to information from intermediaries by a simply written order by any agency or person who is lawfully authorized for investigative, protective, cyber security or intelligence activity. Under Rule 6 of the Draft Reasonable Security Practices Rules 2011, framed under Section 43A of the IT Act, where any government agency may, for the prevention, detection, investigation, prosecution and punishment of offences, can obtain any personal data from an immediate body corporate which stores such data. Okay, now here comes the conclusion. Conclusion is this, that it's about privacy, it's about freedom of speech and expression, and at the same time the state is also responsible for curtailing these cyber crimes. So we need a law, a proper law that also protects your freedom of speech and expression and curtails it only on genuine grounds in order to prevent cyber crimes, and also a law to protect cyber privacy. Okay, if you have any questions, anything to add, or tell this to us, you can any question, anything you want to add? Okay, Myra. Anyone else? Any question? No questions. Okay, then I'm signing off, and it's all right. Okay. Okay, Alamelu. Thank you. Thank you all.